Justice must not only be done, it must be seen to be done. Good evening and welcome to Face to Face. We have with us this evening Miss Bhavani Fonseka, Senior Researcher and Attorney at Law of the Center for Policy Alternatives. And we are going to speak about the progress and the expectations where laws and justice are concerned with this government and with this country going ahead. Welcome, Bhavani. It's been a while since you were on the program.
Hi, Niresh.
Right. Bhavani, it's been just 2 months that this government has been in office. Early days. I mean, there have been huge expectations from the public, and to some, it appears that this government has been in office for much longer, but actually it's just 2 months. So it needs more time to get things going and to move things forward. After all, our previous governments, successive ones, in 2 months, no one was really questioning that they had failed or not carried out on their promises. So there needs to be a little bit more time given. However, the public and the media needs to be vigilant and keep reminding the powers that be that these issues are there, not just in justice, but economy and everything else that goes along with this country. So Bhavani, now let's look at some of the contentious issues which everyone was talking about before the election, the two elections, but don't seem to be talked about as much now because we are not really aware of a lot of progress on these fronts as of yet. One is, of course, the Online Safety Act, the OSA, which was hotly contested, and in fact we at Newsfirst played a big role in ensuring that the first draft of it was not passed. It did not go through Parliament, and the then Ministry of Justice acknowledged this and brought in an amended version, which was passed, but a lot of people weren't happy with that either. And in fact, that government wanted itself to amend that act, but it didn't happen before the election. Now, what's the situation with the OSA, Bhavani? Is it continuing? Is it going to be amended? Where's the discourse around it?
So, Niresh, maybe first we need to revisit kind of where we were in 2023 when the Online Safety Bill was introduced. As you rightly said, many challenged it, many critiqued it. There was this kind of big question, why is the OSA needed, Online Safety Bill, OSB at the time? And this was towards the end of 2023, and a lot of people, when the bill was tabled in Parliament, challenged it in the Supreme Court. It was one of those cases where we were party to the case and we saw a whole lot of citizens coming to court, which is great. What was worrying is the way it passed. You know, it was passed so quickly that no one really understood what happened. And it comes to the whole question of lawmaking process, which we can talk about. But in 2023 and early 2024, there was this kind of huge debate. The opposition in Parliament were raising questions. Why is the Online Safety Bill or the Act subsequently needed? The Supreme Court determination, and even that is questionable in terms of it happened so quickly in the Supreme Court too. But the determination said there should be 31 amendments brought in. So significantly changing the proposed bill. But in Parliament, not everything was brought in, the amendments. And the Human Rights Commission actually raised this question as to the legality of the present law, because the Supreme Court had a determination, said 31 amendments need to happen, but not all of them were brought in. So the present law, the Online Safety Act, I would say is still very problematic in that it has broad language. It can set up this commission, Online Safety Commission, which has very broad powers. The terms are vague, the powers are broad, and there's insufficient checks on this. And the point, I think, in Sri Lanka's democracy, what we need to realize is no one entity should have absolute power. There has to be oversight. There should be checks and balances. And I would say the Online Safety Act and the Commission are deeply problematic in a democracy that should have space for freedom of expression. Now, you are right in that there was so much pressure on the government, and it was brought in by the then Public Security Minister in Parliament. I remember the debate that happened, and he said, we'll bring amendments. And the opposition at that time, that includes some in government presently, said, why are you even proposing amendments? Do away with this exercise. Let's talk about a new law. It didn't happen. They had the numbers, they put it through. The amendments never went through Parliament. So we are stuck with this law that was passed early last year. So it's been a year. And the worry is that if it moves as it is, there is potential for abuse. And who would it be targeted? So I think the backdrop is important, this kind of uproar when it happened. Uproar from the citizens, from media groups, civil society, and the then opposition. And we had 3 members of parliament from NPP who are now in government who were part of that opposition. They were also in court, because we challenged in court, and 2 members of the NPP also came to court to challenge the Online Safety Bill.
Which was very creditable of them at the time. So the expectation was that if they were to come to power and form a government, that they would repeal the OSA or amend it or revisit it, that there would, something would happen.
Well, I think the question is, do we actually need an Online Safety Act? And the then government who brought it, the Ranil Wickremesinghe government's justification was, we need laws to protect women and children, which I don't think anyone disputes. There's so much abuse, disinformation, fake news.
But has the OSA
but that's
been
the whole
used
point.
To protect women and children?
No, and even when it was proposed, Niresh, and this is why the history is so important and the background around this bill, there's only one clause when the bill came about that talked about women and children, which we raised. Everyone said no one is opposing a law to protect women and children. But this law or this bill is seemingly being used to say we're protecting, but really it seems to be giving enough powers to go after critics, going after media, political opponents. And the law now, it's been 1 year, we haven't really seen much. But one can also say without the Safety Commission set in place, the powers are limited in the law. So one would think then when the commission is set up, you would see the full throttle of the law being used.
Well, that stands to reason, because we can't expect a commission to be set up and just to sit around doing nothing. So if they were to exercise the full powers of this act, it might become an abuse, wouldn't it?
It has the potential for abuse, and that's the worry. And as civil society, what we've been saying is, you can't fix the law as it is. It's such a bad law. And I would say there's questions of constitutionality around it, because it still didn't bring in the suggested amendments of the Supreme Court. Now, in that situation, it's important to look at the law and say, okay, why was this? What was the rational purpose of the bringing this law? If it doesn't meet that, let's go to the drawing boards. Let's have a conversation as to see what is best for the people. How do you protect the people who need protection? Now, that is possible, but I'm not aware of that happening. What I'm hearing, and this is just reports, is that the amendments that were proposed last year might go through. Then the question is, why are these amendments that doesn't really address the key concerns being pushed when the potential for abuse is still there? So I would think it's incumbent on the government who opposed the online safety bill, who went to court, who raised it in parliament, to say, look, we'll repeal the OSA, but do it in a proper, transparent manner where people's concerns are raised. And people can also bring in suggestions and do it properly, because they have the numbers in parliament now. The government can really do something, a lawmaking that really reflects the cause of the people.
One thing that the OSA, the entire faulty process that it went through, proved to all of us was that there is an issue with the way our acts can get just shoved through Parliament, practically ignoring the Supreme Court, and then the Speaker signs it and it becomes law. And, you know, this is no way to make permanent laws. If it's something that is temporary, you still have to listen to the Supreme Court. But a temporary law is a temporary law. But this is a permanent one. The OSA is permanent, isn't it?
Yes, and it goes back to this whole lawmaking process and institutions that should be doing its work. So our lawmaking process is very clear. The government can bring in laws, can introduce, it has to go through that process. So the executive proposes a law, a bill, that goes to Parliament. The Parliament should be really, in a functioning democracy, really as a check to be able to critique, improve a law. And then the Supreme Court is there for citizens to challenge a bill. Now, even that's a bit problematic because the time limit in challenging is very, very limited, and people have to come to Colombo, and we've raised this concern. So even the avenues that are available to the public are limited. And what we've seen is, as we've seen with the online safety bill and then the act, is it was rushed through. There was really no conversation. And the question was, why was it rushed through? What was the government of the day trying to achieve by it? And when there's limited then ways of challenging, critiquing, that is even more concerning. So any law, I would say, should go through that process where even before a bill goes to Parliament, the government should have a public consultation, should ask for comments, let people actually be engaged in it. And what we've seen in the last couple of years is the citizen is engaged, the citizen is very vigilant and could actually play a very constructive role. And from that, you send it to Parliament. There are committees that could go into it, that let that process happen. There's no need to rush through something.
But that process needs to be made mandatory rather than be at the whims and fancies of those in office.
Exactly, and there should be actually debate around it. You know, in other countries, there are white papers, there's green papers, there's a whole lot of discussion, and you take time. Now, in Sri Lanka also that has happened, the Right to Information Act. Niresh, you'll remember it went through several years of discussion, formulation, conversation, and we got the law after all that time. Whereas always say in a matter of months it was passed, and it was such a secretive process that it begged the question, was it being done for a particular purpose in an election year? Remember, it passed a year ago, that was January 2024, and we had 2 national elections last year.
But laws should never be made for the convenience of politicians and political parties. Laws are for the public. It's the way the nation is run, not just today or this year, but for decades into the future.
Agree, but the successive governments we've had over the decades have used their power, used the majority they have in parliament to push through, rush through laws, and not just laws. We've seen moments of emergencies where emergency regulations have been used to bring in very draconian forms of governance. So that's why I say the institutions that are there are so critical to play their role. A Supreme Court that is vigilant, that checks the constitutionality, and the Supreme Court can only do that. They can only look at the constitutionality. That's why it's so incumbent that the parliament plays its role, and parliament committees also are able to function. So if it doesn't, you're going to get successive governments pushing through laws that's convenient for them, and that's problematic. But I think we also need to recognize we are in a moment now where I think it's a moment where the government has got a huge mandate, but they also were in opposition. They were with the people in the protests. They know what people have been calling for, a system change.
Absolutely.
A system change then there has to be a different form of governance.
You can't have the same old system.
You can't. You
with
shouldn't.
A new government.
You shouldn't,
People
because it could go horribly wrong.
Yes. But, I mean, it went horribly wrong over regimes, and that's why we ended up in this colossal mess, which is going to take us many years to get out of. And that's economic, it's the legal side, it's everywhere. So this government in office now is expected to ring in some changes.
One hopes so. Changes in governance, changes in the political culture, that citizens should be able to critique, question responsibly. I mean, I'm not saying you just critique for the sake of critiquing, but there's a constructive debate, conversation in where the country should be going. And one recognizes this government has a mammoth task in so many areas. And
absolutely.
And the expectations are high.
Yes. It has to undo decades of mismanagement.
But they also need to do it in the correct way.
In a transparent,
inclusive, participatory way, where the citizens don't feel they're left out of the process. There needs to be communication, and I think it's very important that the government continuously engages and speaks to the citizen, because I think it's when you take office and you forget that dimension that it becomes a very authoritarian governance model. We don't need that. We shouldn't be going down that path. So a lawmaking process should be there that factors in the needs, the grievances of the citizen, looks at the best models, doesn't rush through things, explains, but also meets those international standards in terms of lawmaking. I think that's very important.
Now, you speak of international standards. In many countries, the judiciary has the power to strike down bad laws, or perhaps a couple of decades after a law is passed, society has moved on, the law has moved on, the world has moved on, technology has advanced, and that particular law may become redundant, obsolete, and it needs to be struck down because society has moved on. But in our country, we can't do that. Once a law is passed, we're stuck with it. There's nothing that citizens or the courts can do until a parliament decides to repeal it or to amend it.
So yes, you're quite right. We don't have post-enactment judicial review, and that's a huge flaw in that when a law is passed, for whatever reasons, you're stuck with it. And I think that's a good example if you look at some of the laws like the Prevention of Terrorism Act, which was passed in the 70s, and we're still stuck with it. And there's been a loud, consistent call for the repeal of the PTA. And many governments have said they will look into it, but nothing happens because I think for some who come into power, they realize it's useful to have certain laws. And our system is such that unless there is a repeal, you're stuck with it, or unless there's an amendment, you're stuck with it. So this is the lawmaking process which is problematic. It can be a very secretive process, it can be a very rushed process, very limited checks and balances, and then you're stuck with a law because you do not have the post-enactment review that is there in many other countries, but in Sri Lanka we don't have that.
Well, let's talk about the PTA, Prevention of Terrorism Act, a temporary law enacted in 1979. Temporary? How temporary? I mean, is this still... I mean, I can just envisage 50 years from now, it's still going to be there, you know?
I hope not, Niresh.
Yeah. So,
I really hope not.
This is something which needs to go. I mean, for decades, everyone's been saying it, but nobody who comes to power has actually repealed it.
So again, I think it's important to understand the background, the history. And as you said, it was brought in the 70s as a temporary measure. And the law, actually the title is temporary. So it's really quite ironic that 4 decades later we still have it. Now, this conversation has been there among certain sections of society for decades, particularly critics, political opponents, journalists, minorities who've had to face the brunt of the PTA and the abuse of the PTA have critiqued it, saying continuously, repeal the PTA. And there were 2 attempts genuine attempts, I think, at trying to do it. One in particular was in 2018-19, when there was an effort to try to repeal it. But then the Easter Sunday attacks happened, and then you got into a situation of a security state, and no one wanted to talk about repealing PTA. But the abuse of the PTA is well documented. There's been so much pressure that there's been attempts to amend the PTA, and there were some successful attempts, but the PTA remains. It's only amendments that were brought in.
That's right.
And then I remember in 2020, the then president brought in regulations under the PTA, which was also problematic. So it's not just the PTA as it is. It's also the regulations that could be brought in that infringes on fundamental rights and fundamental freedoms. But luckily, we were able to challenge that. And the Supreme Court actually held with us and said that this was arbitrary, and they struck those regulations down. That was a moment where the Supreme Court really realized that you can't operate the way some governments thought they could operate. But the PTA still remains. Now, the president in his manifesto in 2024 said, repeal PTA. PTA will be, what he said was PTA and other laws would be repealed. We haven't seen much movement. As you said, it's early days. Will the government do it? But it's also important to recognize that in 2023, 2024, around the same time the Online Safety Bill was introduced, the then government brought in a bill called the Anti-Terror Act, or Anti-Terror Bill. And that, again, we challenged in court. And the NPP, members of the NPP who are now in government, also came to court and challenged it, saying this was draconian and this was not the way we should be doing things. So one hopes that this year, it's only January, but I hope the government remembers what they stood by when they were in opposition, and then undertakes a process of genuine law reform and repeals the PTA, because I think there is no place for PTA at this moment in Sri Lanka. So one can only hope.
Well, we certainly hope so. The NPP has a long history of actually opposing unjust laws, unjust bills when they are brought in, and they certainly made sense when they were in the opposition. So there's no reason to think that they would have forgotten all of their promises. I'm sure they must be working behind the scenes at this.
One hopes so.
But also needs to be a public discourse on this.
Yeah.
It shouldn't just be left up to the NPP in government. Everyone else should be part of it. The Bar Association, the courts, organizations
Lawyers,
such as
society.
CPA, the media, and so on. And that's the way we'll finally end up with something which we would all be happy with, or would be the sanest thing to do, I would think. Looking at some of the other laws, the abuse of certain laws. Now, Sri Lanka has a long history of abusing our laws. The PTA is one. The ICCPR is another. This, of course, is a law which is meant to prevent discrimination, or how shall I put it?
Respect rights and
it's supposed
rights.
to respect the rights of other communities, especially whether it is race, religion, or whatever. But it has in Sri Lanka been used to actually persecute people. So here's an example of how things can go wrong.
And I think, again, the ICCPR is also another reminder of lawmaking. I mean, ICCPR Act was meant to reflect the International Covenant on Civil and Political Rights, which is the international standard, the norm in terms of protecting freedom of expression and the right to life, all of that, equality. But what we have now as a law is far from what is meant to be if you look at the international standard. So it's very important, as you also quite rightly said, that citizens continuously question, critique, but is also vigilant. Because we saw recently the ICCPR used to go after comedians, go after media people. And it is a weapon that could be so used to target critics, actors that are, saying something that people could disagree on, but they shouldn't be arrested or targeted on that basis. And the judiciary, luckily, has come out quite strongly and says that in a democracy, there needs to be space for disagreement, that there needs to be space where we can have a debate. And luckily, the judiciary has reminded us constantly. But they remind us constantly because these cases come up where individuals are targeted. And I think it's incumbent for all of us, including the government, including the opposition. I think the opposition has such a critical role to ask these questions too in Parliament, that why are these laws still in place? Shouldn't there be a review of all these problematic laws? If there is to be a law reform process, that process needs to happen. But that's one arm of it in terms of laws and how laws are formulated, drafted, passed, and then implemented. The other is how the laws are used or not used, or cases that are languishing. And I think this is also an important thing to look at, is justice sector and things such as, is there really prosecutions, investigations? And I think that's been a topic of question because the president had the meeting with the Attorney General's Department recently in terms of delays. And then to ask the question, what is the government going to do now with a lot of the cases that have been pending? And again, I revisit a promise the president made, is setting up a public prosecutor's office. I think that's an important thing to look at.
Bhavani, we need to take a short commercial break. I'd like to discuss the Public Prosecutor's Office in more detail with you. Don't go away, we'll be right back.
ICC.
Welcome back to Face to Face. We are in conversation with Bhavani Fonseka, a senior researcher and attorney at law at the Center for Policy Alternatives. Now, Bhavani, just before the break, you mentioned the Office of the Public Prosecutor. This is something which many parties agreed to, or they had it in their manifestos. The NPP, the SJB, so many others. And the reason for it is that there appears to be a clash between the Attorney General's role as the chief officer who is advising the government, and then the other roles of prosecution which the Attorney General has to take up. And we have seen over the decades that it doesn't measure up, it doesn't work. So in some countries you do get a different department, which is the Public Prosecutor's Office. It's an independent public prosecutor. Now, what is the situation with this? And it's not easy to set something like this up. You need to have, you need to set up the entire apparatus, and then you need to find qualified, experienced, upstanding law professionals to staff it. So what is the situation right now?
So again, I think it's important to kind of take a step back to see where is this coming from. And there is, unfortunately, in Sri Lanka, many cases that have got stuck in courts or at the investigations level, and really nothing has happened. And I think for many victims over the decades, they've just said there's been a delay in terms of getting the cases through. Now, there could be different reasons for it in terms of the evidence that's lacking, or there's just the witnesses are no longer around or willing to come forward. Now that's another issue that one needs to look at. Or it could be that the officers that are meant to prosecute are inundated, are stretched, and as we've now seen, there's been media reports, there's also many vacancies in the Attorney General's department. So I think the existing few who are in the department are stretched thin. They are handling so many cases. And so there's been a call from the people for a long time that things need to move forward. And what can be done is to then make the existing actors efficient, ensure they have the resources, the expertise, all of that. But what we've seen is that alone may not address the problem. And that's where many of us have been saying, set up a prosecutor's office, an independent prosecutor's office that is purely focused on prosecutions. And that call became louder and louder with the economic crisis, where people said, we are now aware there's so much corruption, economic crimes that have happened that requires people to look into it to see if there's enough to prosecute. So you can start with maybe a particular caseload, like the cases of corruption, which now have been in the public domain, there is some movement on arrests, but very limited movement in terms of prosecutions. So if you look at that caseload and say, if you set up a separate office that just looks at it, has the expertise, resources, maybe you actually can make some progress. But you're then setting up, as you quite rightly said, a whole new entity. And for that, then one has to look at how do you set up a whole new entity? How does it work within the present existing systems? But also lessons learned in terms of you have to have the right people of integrity who can push forward, who are not going to be pressured or, influence or otherwise. So there's many, many challenges. So I think it's important to ask the question, how is this possible in terms of the legal structure, the technical expertise, but then also, is there political will to do it? And I would say a government that promised so much in the manifesto articulates the public prosecutor, it's incumbent on them to now come out and say, this is our plan, which again, it may be early days, but you need to start talking to the people as to how to implement your manifesto, which we haven't seen. So absolutely. I think it's really important to ask the critical questions of the government as to how do you plan to implement the promises you made in 2024.
Right. And don't you think it would be to the advantage of the government to engage in this transparent discourse with the public, with civil society? It would actually strengthen the government's own reputation.
I totally agree. And I think this is the time to do it, where, again, early in the year, have conversations, come up with a plan. If it's in the manifesto, there would have been some thinking in terms of why they felt it should be in the manifesto. So take it around, go and speak to the people, have town hall meetings and get this rolling. Now, if there's real political will, I think this government can do it because they have a good machinery, they have the ground work, the presence in the areas. But then I think the question also is everyone in government and in the structures open to this? And that's the other question is, are investigators, are other individuals, entities that need to be part of this process okay with it? Because, if a public prosecutor is allowed to function and starts prosecuting, one needs to also start thinking, who are they going to be prosecuting? So there will be an opposition from sections who feel threatened by an entity. But regardless of that, I think it's incumbent on a government that promised to now start implementing and rolling it out, right, but in a very transparent manner.
Right. And I think it's important to remember that the NPP's manifesto was not just simply 10 people sitting down and writing what they felt was good enough for an election campaign. I believe there were about 24 specialist committees made up of professionals from those areas who looked at, for example, tourism. It was a set of tourism professionals who wrote that section of it, and then it was added on to the manifesto. So the NPP's manifesto was in fact a more specialized document than the manifestos that we usually see, in that the authorship was quite broad-based.
Yeah, and I can't speak to their methodology in how they did it, but that manifesto resonated with the people. And I think that's what we can take out of it too. We had 2 elections. People voted on the basis of what was promised. So no one can say this government doesn't have the mandate to now start implementing it. And some thinking clearly went into that. So it's a good starting point. Now, we are fast coming to the end of January, in a week's time or so. And I think it's important now for the government to say, look, we got this mandate through 2 elections. This was a promise. This is our plan, and start now delivering. But of course, I don't expect these structures to be immediately set up. I mean, that goes against what I've been saying in this show. It also requires time. So if you need 3 to 6 months to take that process, to have the consultations, to draft a law in a transparent way where you bring in the expertise, suggestions from different bodies, including the Bar Association, do that, but show that you're doing it so that people know in a couple of months, there will be an entity that can actually take forward the cases of corruption. And there's massive corruption that we've been publicly, we've heard about. Now is the time to actually look into it and start prosecuting.
Right. Now, as to the point of can proper professionals be found in Sri Lanka to staff such an organization? It's actually, although it's very much related, it's the other side of the coin, isn't it? You can't wait until you find a whole group of great people before setting up the office. You've got to set it up and then, figure out.
You could do it at the same time in a way. I mean, and that's why I say passing a law, setting up a structure shouldn't happen overnight.
Right.
It takes a few months, I would say a few months. So take the first half of this year to do that properly. And while you do it, look for those individuals, look for the technical expertise and the resources. If it's corruption, if one is looking at corruption, those are complex cases. You may need technical assistance expertise from elsewhere. Is that possible? So that requires time too. Now, corruption cases came to the fore because of a lot of the work done by the NPP themselves when they were in opposition. There's also considerable work done on some of the emblematic cases on human rights violations,
right.
Killings, abductions of media personalities. There was some investigations done into this a couple of years ago. So I think there's also work done in that area that's worth looking at.
Absolutely.
Because, impunity is both with human rights and economic crimes. And, sadly, we've seen the fruits of impunity get to a point where we had a very authoritarian, corrupt government in place. We don't want to go there. So to ensure we don't repeat those mistakes, I think you have to go at the heart of impunity, but do it in a manner which is transparent, that due process is followed. We do not want a situation where people feel they're targeted or politically victimized. So I think whatever is done needs to be done properly. Learn from our recent history. There's been so many cases of political victimization. It shouldn't be seen in that manner.
Well, you're talking about the high-profile cases, Lasantha Wickrematunge case, the Tajuddin case,
Pradeep Egnaligoda, Keith Noyer, there's a long list.
Exactly. You're right, some investigations have been done. Maybe some of them require more thorough investigation.
But Neeraj, look at, for example, even the Easter Sunday attacks. We've had presidential commissions of inquiry. We had a parliament select committee. Some work has been done in many of these cases.
Absolutely.
It's not doing it all new again. So it may be worthwhile, think you're setting up this institution, passing laws, that there is an arm that starts looking at these cases, where things stand. But also then asking the question, for example, the NPP, when they were in opposition, had a lot of files. Do those contain information that can start a process? So there could be different sources that are used. As long as those are credible sources, that they are used in the proper manner, I think, it doesn't need to be one avenue of information. There's, I think, quite a bit of work done in Sri Lanka that one can start with.
But it's also important that when a case is finally filed, it needs to be a solid one.
Of course.
Because if the culprits are simply going to be found not guilty after a year or two, that defeats the whole purpose, doesn't it?
And I think that also comes to this question that we've seen in recent years, the Attorney General's Department filing charges, withdrawing charges, withdrawing indictments, raises this question of the independence of the Attorney General's Department. In high-profile cases, we've seen this. And that also fueled this demand to set up a public prosecutor's office. That, why is institution filing charges, but then later withdrawing charges, saying there is no information? So that's why I say that process has to be so solid and credible, that if there's no information, charges, there shouldn't be a prosecution done. It's only when there's enough evidence that it should be done. Now, that may upset people who've been demanding for justice for a long time. But then that's where also the communication strategy has to be there, where there is an entity that says, look, we've looked into it, we followed all the sources, but we don't have sufficient information, evidence to file a case.
Now, the Attorney General's Department does have a little bit of a credibility issue, and I'm putting it mildly, because in many of these high-profile cases where there seems to be a lot of evidence, nothing much has happened. However, this same AG's department, and I'm not going to blame any particular Attorney General or official, but the same department has gone after poets, comedians, media personnel, playwrights, and so on. So there's clearly a lot of political pressure, which of course means that the independent public prosecutor is that much more important.
And I think, we're not attacking individuals. I'm more looking at how do you have a system that works for the people, works for the citizen. And I think over the years, over the decades, what we've seen is some institutions have been prone to pressure, interference, that, it's then to make sure how do you use the existing to this, but possibly have new entities that could complement this whole task of greater governance, greater transparency, good governance. So I would say, we're not saying remove the Attorney General's Department. We are saying maybe kind of, redefine that they do the work to the best of their abilities in a particular way. But in particular areas, such as prosecuting corruption cases, maybe it has to go to a very specialized entity.
Well, something that I learned over the past couple of weeks was that South Korea has a special department for high-profile corruption and other cases. So when the president declared martial law and then had to walk it back a few hours later, and then, of course, he was impeached by Parliament. But at the same time, this particular department started up its investigations independently. And it is that department which called for the arrest of the president, who is still the president, although he's in limbo until the Constitutional Court decides his fate. But he still has the title of president. And of course now, after a big ruckus, he was actually arrested. So that's the kind of department which we need, which would independently take decisions and
not be politically pressurized. So I think we should be heading towards that. I think it's a long road, but I think we now have a moment where these are possibilities. And I think it's also, in a way, lucky that we have a government who spoke to these issues in 2024. So incumbent, we keep the pressure.
Right. We are running out of time, but my final question is, what of the executive presidency? And this is the million-dollar question for the last, oh my goodness, I think it was President Chandrika who, when she was in the opposition, raised this issue and promised to abolish the executive presidency, and it's still here.
Yes, and you saved the big question till the last, Neeraj. But I think, again, this call for abolishing the executive presidency has been there for decades. I think most presidential candidates promise it, but then conveniently forget it. We came close to kind of looking at it a few years ago in terms of the constitution reform exercise that happened, but it never fully realized it's that process. So we're stuck with the office. This president also in his manifesto said abolishing the executive presidency, and then said that last year was the last presidential election this country would see. So promises have been made. Will they be delivered is the question. Now, that abolishing the executive presidency is a long, constitution reform. It needs to then follow through. There will need to be a referendum, and all of those things have to happen. So when is the question? When and how? Considering this government has many challenges. But we keep saying if you don't move on it within the first year, it's going to get harder and harder. So I hope 2025 is the year we see abolishing the executive presidency, setting up the public prosecutor, repealing the PTA, I would say even repealing the OSA and many other laws. So I live in hope that this will all happen.
Well, remember that a journey of 1,000 miles begins with a single step. My thanks to Bhavani Fonseka, a senior researcher and attorney at law at the Center for Policy Alternatives. Thank you very much for being with us once more. And thank you to you at home for watching. The news is coming up next, so don't go away. Have a good evening.
Our development era kickstarts from 2002-2005.
If you're off duty, right, you're entitled to do what you